Okay. Mr. Massey, I believe you are here for the appellant today. I'm afraid I'm not hearing you for some reason. Okay, now I've got some sound.
Better?
Yes, ma'am. Yes,
Thank you, Your Honor.
Sure thing. Would you like to reserve any time?
Yes, sir. I'd like 5 minutes for rebuttal, please.
You got it. Go ahead.
Thank you. May it please the court, I'm Marie Tomasi from the Trenum Law Firm. I'm here on behalf of the appellant, Precision Orthopedics. And let me begin by simply an overview saying this is an appeal from the trial court's order dismissing all 6 counts of Precision's amended complaint with prejudice based solely on the trial court's conclusion that the relevant terms of the 2004 addendum had expired. But the parties' agreements attached to the amended complaint and the allegations of that complaint established the contrary. That is, that the 2004 addendum was incorporated by the 2008 addendum between these parties, while the 2004 addendum was very much still in effect. It had nearly a year, just 1 day shy of a year left in its term. And the parties expressed their intention and desire in the 2008 addendum in the 4th whereas clause to amend, modify, or supplement the 2004 addendum and the representative agreement. Now, the 2008 addendum's term didn't end until the end of December 2013. And the parties agreed in paragraph 13 of the 2008 addendum that if any provision in the 2008 addendum conflicted with the 2004 addendum that it had incorporated, then the 2008 provision controlled. And so what you have is the 2008 addendum incorporating the 2004 addendum, and that extended the 2004.
Ms. Tomasi, so my question on that point is, in each of the addendums, they define the term. The 2004 addendum is defined as the addendum term. In the 2008 addendum, the definition of term is defined as 2008 addendum term. And then the 2013, to no surprise, defines it as the 2013 addendum term. And so I don't see how those are conflicting when they specifically define the terms. And in the 2013 addendum, they refer to the Zimmer contract and specifically to the 2008 addendum term. So explain for me how that extends a specific term in the 2004 addendum, which is only defined as the addendum term.
Your Honor, the 2004 addendum was the first addendum of the parties, and it was actually referred to not by the year of Correct. 2004, but as the initial term. And this becomes important when you get to the 2013 addendum, where I just turned, so I have the exact language in front of me, where in paragraph 2 of the 2013 addendum entitled term, the parties agreed that, and I'm going to quote you here, notwithstanding anything to the contrary contained anywhere in the Zimmer contract, which they had agreed earlier in that addendum was defined.
Well, let me go back, because you just said that the addendum term in the 2004 was referred to as the initial term. I think you're talking about is that not the representation agreement that called it the initial? Because if I'm looking at the addendum for 04 in the defined term subsection 2, it says addendum term. The term of the effectiveness of this addendum shall be for a period, and then parenthetical, the addendum term, not initial period.
I'm sorry, Your Honor, you are looking at the 2004 addendum.
Yeah,
correct?
Correct. Yeah, and it defines the term not as the initial term, but it defines the addendum term as the addendum term without a year, because obviously that would have been the first one. It would be my guess, right?
Right.
Okay, I just want to make sure I'm on the same agreements with you.
No, you are, Your Honor, but my point being about it being their first one, their initial agreement, is important when you look at the 13 addendum. And I'm just going to cut right over to that one, because although there is one thing I need to back up on the 08 addendum in a minute, but let me talk about that 13 addendum for a second.
Okay.
Keep in mind that the parties at the end of 2013, their agreements all expired, all their addenda and the representative agreement. And they continued working together and they continued negotiating. And they didn't actually enter what we've called the 2013 addenda until later in January of 14. But they made it effective back to December 31 of 13, just to prevent it having a gap without a contract, right? But at the time, in the beginning of January, they had no contract. So my point about this is when they come back together and they agree to move forward and they draft this addenda, they don't say that this is only effective going forward. They say that notwithstanding anything to the contrary contained anywhere in the Zimmer contract, which they had just defined in this very same 2013 addendum in the earlier provision as the representative agreement and all addenda between the parties.
So to the point that's made by opposing counsel here is that, well, okay, they talk about the initial term of the representation agreement, then they talk about the 08 addendum term, but nowhere do they talk about the 2004 addendum term. And so to go back to the Latin phrase of expressio unius e exclusio alterius, which I probably didn't pronounce correctly, but the exclusion of one is the exclusion of the other. And so here, if I look at the recitals, and mind you, the recitals are not the terms, they are simply, we can look for the intent. The last whereas clause says the company and the representative now desire to further amend the Zimmer contract and including but not limited to certain amendments to be made to the 2008 addendum pursuant to it in accordance with the terms of the 2013. Nowhere am I directed that this has anything to do with extending the 04 addendum. So I guess that, and so you help me, but that's kind of where this is directed. And I'm just not seeing the leap to extend the addendum term in the 04.
Okay, Your Honor, I understand what you're asking me, and I would like to revert back or go back to what I was saying about the 08 addendum, because I think it might address your concern. When the 2008 addendum incorporated the 2004 addendum, when the parties agreed to do that, the 2004 addendum was not expired. So it was incorporated into the 2008 addendum. And in that addendum, the parties expressly stated and agreed that all terms and conditions of the representative agreement as amended by the 2004 addendum shall remain in force. Now that
so where am I directed that the term of the 04 addendum would have been extended?
Well, Your Honor, it's extended because it becomes, the 2004 addendum becomes part of the 2008 addendum by being incorporated into the 2008 addendum. And this provision would make no sense, the one I just quoted, would make no sense to have if, in fact, the parties were saying it's done. It's a dead point. And then I might not be able to agree with Your Honor that the reference in paragraph 2 of the 13 addendum to the initial term and the 08 term refers not to the 2004, or that the language about notwithstanding anything to the contrary is irrelevant. The parties, it seems by this language, were making very clear their intention to continue operating the way they had been all along. If they believed that the 2004 addenda expired in 2008, shortly after the 2008 addendum, within a year, then why did Zimmer and Precision continue operating in the same fashion, honoring the exclusive territory, the commission arrangements for whoever made sales in that territory, if it wasn't Precision having the commission having to be paid to Precision, et cetera. These other 2004 addenda provisions, why did they continue honoring that all the way through until the Zimmer Biomet merger? And that is why we think the language is clear. We think the intent of the parties tracks right through from one addenda to the next. But clearly the trial judge got stymied by something along the way. Your Honor seems to be having an issue with where is the reference to extending the 04 term, but the conduct of the parties is consistent with our interpretation and Precision's interpretation. And that is when in the amended complaint, that is why in the amended complaint, after the trial judge struggled with and actually disagreed with our position, we went into the amended complaint and added allegations regarding the parties' conduct all the way through their relationship until that merger happened, that was consistent with our position about the efficacy of the 2004 addenda. And that created, at a minimum, if you can't agree with us about how it's clearly read, it had to have created at least a latent ambiguity. Because as this court has said in some very useful and instructive cases, a latent ambiguity arises when language that might otherwise appear clear is rendered ambiguous by extraneous events or circumstances. And one of the cases that I think is useful particularly is the Barrington case in 2010, because in that case, the extraneous circumstances was the fact that the defendant, real estate broker, there was evidence that that real estate broker had not applied or used the provision regarding withholding commissions from a departing agent in the same way in other instances as the real estate broker was claiming was the only way to read the contract in the Barrington case. And the court, this second district, said that extraneous evidence or that evidence is the extraneous circumstance that demonstrates a latent ambiguity and makes a summary judgment reversible and improper, because there is a need for an interpretation or a choice among two or more possible meanings. And so here, this this latent ambiguity that we allege the facts to support in our amended complaint didn't even get to a summary judgment, which still would have been improper according to Barrington and Mac Gray, another great case out of this court that we cite in our briefs, because it would have resolved an issue of fact. But we were even way before that, when the test is, did the complaint, or in this case, the amended complaint, allege causes of action as a matter of law based on the allegations and the exhibits. And so we believe that the language means one thing and the parties acted in conformity with what we believe until the merger.
Ms. Tomasi, just to let you know, you're now coming up into your 5 minutes. You can continue if you wish.
Where'd my time go, Judge? Thank you. I appreciate the warning. The only other thing that I would want to say before I get into all of my rebuttal time is that this was the basis on which the trial court dismissed all 6 counts, even the 3 or 4 that don't turn on the language of the contracts. For example, count 3, 5, and 6 are plainly not dependent on whether the 2004 provisions continued. And so
you can address this now or when you come back and rebuttal, but I want to hear what you have to say about their claim on 5 and 6 for not having the actual contracts attached, and the failure to do that being a reason that the judge should have granted the motion to dismiss. You all chose not to amend that, but I'd like to hear more about that issue on those 2, and you can do that when you come back if you prefer.
Okay, thank you, Your Honor. I will do that on my rebuttal so I can do it. I'll figure out how to do it quickly while I'm sitting down. Thank you.
Sure thing. Okay, we'll have 3.5 minutes in rebuttal. And Mr. Brown.
Good morning, Your Honors. May it please the court. I'm Troy Brown. I represent the appellees, Zimmer US Inc., MedTech Southeast, and Orthopedics Inc. I'll begin essentially where Judge Smith's questioning started, excuse me, and point out that on an express contract case like this, context matters. And context matters when the contracts provide the express contract context for the court, which is what the trial court saw. The 2004 representative agreement is the governing overarching master agreement that governed these parties' rights and obligations. And in that master agreement, very clearly in paragraph 4, Zimmer was provided sole discretion to decide what its distributors, here Precision in Florida, would or would not sell within the territory. And in particular, it provided Zimmer sole discretion to determine at some point if they acquire new products in the future, including from an acquisition, which is what actually occurred in the summer of 2015, whether or not to have Precision or some other distributor distribute those products. Now, context again matters because we see expressly in the 2004 addendum what the context was leading to certain of the provisions, including the key provision, paragraph 8, on which is the linchpin for plaintiff's case, would apply. The reason that these special incentives were provided to Precision and Mr. Etheridge, its lead principal, for 5 years under an express 5-year addendum term was because Mr. Etheridge had recently sold his controlling interest in the business, and there was a concern that he would retire within the next 5 years. So the addendum term, excuse me, does more than just make it a 5-year term. It's actually an earlier of term, as your honors have seen in paragraph 2. It's the earlier of his retirement as defined or 5 years. And then there are certain special incentives he gets, including $10 million, a $2 million per year payment over 5 years to the extent that he continues to the end of that 5-year addendum term. And then the key defined addendum term incentive, which is in paragraph 8, that abrogates Zimmer's sole discretion for a particular 5-year period. And that discretion to change the rules of the game with respect to what products Precision would have the exclusive right to sell and not sell within the territory were abrogated expressly for 5 years. There are other provisions that I think were implicit in Judge Smith's questions in the 2004 addendum that were not subject expressly to the addendum term, including, for example, paragraph 7 dealing with conflicts. That is not subject to an addendum term. That is a term in a 2004 addendum that can continue in the future if the parties decide to, as part of their negotiations. Now, we move forward, and there are 5 more addendums entered into between these parties over the course of 2006 through 2013 until the relationship ends at the end of 2018. And not a single addendum, and the parties knew when to specifically reference extending certain agreements and when to expressly apply particular terms when they wanted to. Because you only
Mr.
have
Brown,
but yes.
Mr. Brown, to Ms. Tomasi's point, I mean, this is at a motion to dismiss. It's an order granting motion to dismiss with prejudice and eliminating the case. And so Ms. Tomasi raises the issue that there was this latent ambiguity in the agreements, or I'll say the contract with all the addendums, and that the course of conduct of the parties should have been brought out and allowed the case to be decided on the merit as to whether or not the parties were still continuing to pay under the 04 addendum as if the term was extended. So to that point, shouldn't this have just been vetted out at a summary judgment so that the case could have been decided on its merits as opposed to a motion to dismiss?
Thank you, Judge Smith. No, it should not. There is no ability for a plaintiff taking a position regarding latent ambiguity that doesn't appear on the face of the documents and the contracts. The trial judge here appropriately looked at the 4 corners of these agreements and determined that there was no latent ambiguity, which is within the province of the trial court.
I want to make sure I understood what you just said, Mr. Brown. You're telling me that a latent ambiguity has to be apparent within the 4 corners of the instrument?
No, Your Honor. I'm saying that if the 4 corners of the contract are clear and expressed subject to one determination and one interpretation, it is the trial court's province on a motion to dismiss in a contract action to look at the 4 corners and not allow an argument that, because there are competing arguments about what contracts say, doesn't by definition create a latent ambiguity. Otherwise, no contract claims would ever be dismissed on motion to dismiss, despite how clear they are.
Okay, so then is this something then the court could have looked at based on their argument as a subsequent course of conduct?
The course of conduct, a course of dealing, and oral modification argument that plaintiffs raised in their amended complaint to try to work around what they didn't argue in the original complaint, because drawing the court back, the panel back, the original argument was this contract is clear and unambiguous, and it's in our favor, precision. And the judge disagreed. So in the amended complaint, they said, well, we still think it's clear, but there was at a minimum an oral modification enforced and informed by course of dealing that should be looked at here to get us over the motion to dismiss hump. And that fails for 2 reasons. First, there is no contrary course of dealing leading up to the June 2015 merger that could possibly lead to some sort of a latent ambiguity requiring parole evidence. Why? Because from 2008, at the completion of the addendum term until the merger in June of 2015, what the parties did was operate under the reversion to paragraph 4 in the representative agreement, the governing agreement, which gave Zimmer sole discretion.
But doesn't,
I'm sorry, go ahead.
I'm sorry, Judge Lucas, just go ahead.
No, I was just going to ask, and maybe it's the same question you were going to ask. How do we know that outside of the 4 corners of the pleading that the trial court was bound to make its ruling under?
Because, well, you don't, again, to step back 1 second, Judge Lucas, you don't get to introduce an argument of latent ambiguity for a contract that on its face is express and only subject in the trial court's view to one interpretation. This 2004 addendum expressly provided that the addendum term ran through 12/31/2008, period, end of story. There's not a single other contract in this case, addendum or otherwise, that expressly extended or sought to revive a long terminated special addendum term. In fact, in the 2013 addendum, Your Honors, where the parties looked to the original representative agreement, the 2004 representative agreement, not the 2004 addendum, they looked to it and they said, we're going to take the representation agreement from 2004 and we're going to extend that 5 years, extend the initial term, which was 10 years, 5 more years till the end of 2018. The parties expressly, without parole evidence, knew how to adopt, incorporate, and apply a particular term. And what they did in 2013 was not look at the addendum term in 2004 addendum, but look at the 2004 representative agreement and say, we're going to extend this 5 more years till the end of 2018. Now, when we looked at the oral modification and course of dealing arguments that were raised in connection with the amended complaint, both parties briefed and addressed the Okeechobee elements. Okay, how do we get around a fully integrated agreement that one party suggests is somehow ambiguous or modified by an understanding based on course of dealing, which was what plaintiffs argued under at the trial.
I'm going to help you with your argument, because doesn't this really just boil down to the clause in 15? It's the entire agreement. It has to be modified in writing. I mean, we didn't have any modifications in writing. I mean, so doesn't that argument as far as subsequent conduct and oral modifications, isn't that gone with the paragraph 15? So
it certainly is, Judge Smith. What plaintiffs have tried to argue, what appellant has tried to argue, is that they somehow alleged in the amended complaint to satisfy the Okeechobee test to suggest that the parties somehow agreed to this, both parties. They both acted in a way consistent with this alleged oral modification, and that Zimmer somehow benefited from this. And as we know from the record, and there's no dispute in the underlying allegations in the complaint, as of June 2015, when Zimmer and Biomet merged, Zimmer did not act consistent with any alleged oral modification that would give Precision some rights to sell legacy Biomet products within the territory. In fact, both parties acted consistent with the original 2004 representative agreement, because this isn't a situation where Precision stopped selling and immediately sued and said, hey, we're entitled to sell all products, including legacy Biomet. What Precision did was take the next 3 years and act exactly how they had from 2008 to 2015 under Zimmer's sole discretion, which reverted to the 2004 representative agreement after the addendum term ended. And what they did was sell legacy Zimmer products for 3.5 years and make a good profit doing so. They didn't act consistently with an understanding that they had some revitalized or revived from the dead rights under the 2004 addendum term in paragraph 8 that had now been dead by that point for 7 years. What they did was act consistent. It was only after they didn't get extended at the end of 2018 that they sued and claimed that going back, the 2004 addendum didn't terminate on December 31st, 2008, but it continued essentially in perpetuity for the 15 years of this contract. I'll shift gears, unless the panel has other questions on the contract issues, to the tortious interference claims that...
Before you get to the tortious interference claims, what about count 3? Let's not forget count 3.
Yes. So count 3, Judge Lucas, is candidly a count that should be reversed and remanded. And we dropped a footnote in our briefing, and it's no disparagement to my opposing counsel, genuinely. But I believe we could have resolved that approximately $50,000 claim. We tried, we couldn't. I think appellant wanted a live claim coming into the appeal.
It happens.
So that sits out there.
Whatever it was. Okay.
Yes. But yes, that is an open and live claim that should be reversed and remanded to be resolved, I suspect, within days. Shifting gears to the, if there are no more questions on the contract interpretation issues, shifting gears to the declaratory judgment count 4, that's, we believe, wholly derivative of the contract claims. And in particular, there's two elements here. One is the derivative nature, which is if Zimmer Biomet did not materially breach the underlying contract because they had the sole discretion under the 2004 representative agreement, there can be no live controversy concerning whether or not a material breach thereof gave rise to an excuse for Precision to comply with the non-competes. In any event, because of the timing of this and the fact that we're here on August 31st, 2021, that claim is essentially mooted and no live controversy because it was a 2-year non-compete for 2019 and 2020. There are no active non-competes being enforced as against Precision because the 2 years ran out. So because of the trajectory of the appellate argument, there's not even a live controversy if we were wrong on the material breach, which I respectfully submit we're not. With respect to the tortious interference claims, I want to address them quickly, separately. Count 5 is distinct from count 6. I'll start with count 6 because there was the question on that. Count 6 relates to tortious interference by only one of the appellees, Orthopedics, with respect to whether or not Orthopedics somehow tortiously interfered with 2 of the former Precision employees' later employment with the company. They had 2 bites at the apple here on the allegations. They could have alleged exactly what the non-competes say. They could have attached the contracts. We raised that in the original complaint. They failed to do so in the amended complaint. They could have spelled out what the alleged acts of inducement were on the original complaint. They didn't. They didn't do it on the amended complaint either. And they could have tried to explain what the interplay between this amorphous ERHM non-party and what rights they do or don't have in these non-competes, and they did not. This is an insufficiently pleaded count. The judge actually, as you've seen in the second dismissal, gave Precision one opportunity to voluntarily seek leave to amend the third time to try to correct the record, and they elected to appeal instead.
Help me out with that. Just procedurally, I got to confess that was a curveball. I'd not seen that before. How do you dismiss a complaint with prejudice, but in your ruling say, but I'm going to give you another opportunity to, if you want, you can try and ask me, Mother May I, to plead a claim. I mean, was it dismissed with prejudice or wasn't it?
Well, so I think the parties thought it was dismissed with prejudice. As your honors might have seen on the appellate record, there was some lack of clarity, including with this panel and with counsel, about when it was or wasn't dismissed with prejudice, and the parties cooperated to make sure that this appeal stayed on calendar for today. That being said, Judge, I have seen repeatedly in cases with serial complaints in Florida and in federal courts where the judge will dismiss a complaint with prejudice, but give a window before docketing the judgment for the party to move for leave to amend to try to correct one or more issues that have been identified now for the second time warranting dismissal. And certainly Precision could have done that, and the judge actually invited it. So from a true nuanced procedural standpoint, could it have been done with better clarity in the articulated motion for leave invitation? Probably. Is it of no moment? I think ultimately procedurally, yes. And clearly Precision wasn't interested in appealing, in amending, because they didn't ask for clarity or ask to amend. They simply docketed their appeal. With respect to count 5, which is a different tortious interference claim, that's also a derivative claim, essentially, because if Zimmer Biomet didn't materially breach or wasn't induced to materially breach some underlying agreement that didn't give them sole discretion, which we think they clearly had, if the contract claim falls, so does count 5's tortious interference claim, because you can't tortiously interfere and induce a party to breach a contract where they have the rights to do exactly what they did, setting aside the pleading deficiencies about how these 2 small Florida distributors who sold legacy Biomet products for years induced Zimmer Biomet to not provide the opportunity to Precision and provide it to them instead. And finally, they've raised some arguments in their briefing about the impact of expired or terminated or unenforceable contracts, and they cite a couple of these broker-dealer cases where the seller and buyer collaborated and conspired and cut the broker out. The broker actually did a lot of work and didn't get paid. This is the exact opposite. Precision's not suing here, claiming that they sold a bunch of legacy Biomet products between mid-2015 to the end of 2018, and we failed to pay them because at some point we said, you know what, you never had the right to do that, and we're not going to pay. It's the opposite. They didn't sell legacy Biomet products. They sold legacy Zimmer products. They made profit on legacy Zimmer products through the end of the contract. They made a lot of money over 15 years under that arrangement. And so these two broker cases where the broker was cut out did work, did things, and didn't get paid, where the party said, well, contract's unenforceable, so you're not getting paid. Complete opposite situation here. If the panel, I don't know where I am on time, but if the panel has any more questions.
You have about 2 more minutes left.
Unless the panel has any questions, I'm happy to rely on the briefing.
All right, thank you very much, Mr. Brown.
Thank you very much, Your Honors.
Ms. Tomasi.
All right, thank you, Your Honor.
About 3.5 minutes.
Going to start running. So let me start by saying Zimmer loves to argue facts that are not in the complaint, the amended complaint, or the attachments to the amended complaint. And I would ask the court to take a hard look at any of those facts that the court might think are important, because they may not even be in those documents, which were the only things the trial court was supposed to be looking at in reaching its conclusion as to the sufficiency of the complaint to go forward. For example, most of what Zimmer argues as the reasons for limiting the term of the 2014, et cetera, or excuse me, 2004, their whole argument about why those provisions were limited, most of that is nowhere to be found, or it's misdirected. Like the whole thing about the money being paid to George Etheridge or to the other principals involved in Precision, that is completely unrelated to the provisions that govern the relationship going forward between Precision and Zimmer. And it's more of a distraction and a red herring intended to suggest perhaps that they'd already got their money, so don't worry about it. It's really important to recognize that in early January of 2014, there were no contracts anymore between these parties. And at that point, Zimmer could have come in and said anything it wanted, like, we're not doing that exclusive territory thing anymore. We want to strike out these provisions. We want to make sure it's clear this. Anything they wanted to negotiate, but instead they came in and agreed to continue their business relationship as it had been going all along, which our complaint, amended complaint, alleges was consistent with how we read the contract. And the judge was not free to disregard the latent ambiguity, because Zimmer's counsel is completely wrong about the reading on whether a latent ambiguity must be plain on the face of the language. If that was the case, there'd never be a latent ambiguity. The whole idea, if this court looks at the Barrington decision and the McGrave for 2 good examples, is that something extraneous to the agreement creates the ambiguity in language that otherwise appears clear. So I know that I'm going to run out of time, and I have to address the tortious interference question. So I don't want to ignore that. Yes, so I'm just going to move to that and make sure I don't ignore the question that was asked of me at the end of my time. Count 6, the tortious interference with contracts against orthopedics was based not on a contract agreement with orthopedics but with, let me rephrase, let me start that over. The tortious interference claim was based on the essential allegations that are set forth in that count, that Precision and its affiliate had employment contracts with their sales representatives that had non-competition and non-disclosure and other requirements, that orthopedics knew about those contracts, and that notwithstanding those contracts, they wrongfully induced 2 of the sales representatives to leave the employment of Precision and its affiliate and go work for Orthopedics. So Precision was not suing Orthopedics for breaching the employment contracts. And therefore, the employment contracts did not need to be an exhibit to the complaint or the amended complaint. Now, certainly in count 5, also, that was a tortious interference with the business relationship. And the amended complaint alleged that MedTech and Orthopedics it was based not only on their actions in getting appointed by Zimmer Biomet after the merger to be distributors in Precision's territory, but also on their conduct in doing that and in being in that territory that caused customer confusion and concern by surgeons with whom Precision had longstanding relationships. And
Mr.
so,
Massey, you're going to need to wrap it up.
Okay, thank you, Your Honor. And so in effect, we're not arguing for an oral modification. We're not asking for this court to rewrite a contract. We are asking this court to look at the propriety or lack of correctness of the trial court's decision on a motion to dismiss limited to the allegations in the amended complaint and the attachment, and not on the argument of counsel or client.
Thank you very much.
Thank you.
At this point, we're going to take a 10-minute recess, and then we will call the last case on our docket. Thank you both.